both the life and limbs of a man are of such high value in the estimation of the law of England, that it pardons even homicide if committed se defendendo, or in order to preserve them. For whatever is done by a man to save either life or member is looked upon as done upon the highest necessity and compulsion. Therefore, if a man through fear of death or mayhem is prevailed upon to execute a deed or do any other legal act, these, though accompanied with all other the requisite solemnities, are totally void in law, if forced upon him by a well-grounded apprehension of losing his life, or even his limbs, in case of his non-compliance. And the same is also a sufficient excuse for the commission of many misdemeanours, as will appear in the 4th book. The constraint a man is under in these circumstances is called in law duress, from the Latin duritius, of which there are 2 sorts: duress of imprisonment, where a man actually loses his liberty, of which we shall presently speak, and duress per minas, where the hardship is only threatened and impending, which is that we are now discoursing of. Duress per minas is either for fear of loss of life, or else for fear of mayhem, or loss of limb, and this fear must be upon sufficient reason. None, as Blackstone expresses it, quote, suspicio cuius libet vani et meticulosi hominis, sed tales qui possit cadere in virum constantem, tales enim debet esse metus, qui in se contineat vitae periculum aut corporis cruciatum. A fear of battery or being beaten, though never so well grounded, is no duress, neither is the fear of having one's house burned, or one's goods taken away and destroyed, because in these cases, should the threat be performed, a man may have satisfaction by recovering equivalent damages, but no suitable atonement can be made for the loss of life or limb, and the indulgence shewn to a man under this, the principal sort of duress, the fear of losing his life or limbs, agrees also with that maxim of the civil law, Ignositor e qui sanguinem suum qualiter redemptum voluit. The law not only regards life and member, and protects every man in the enjoyment of them, but also furnishes him with everything necessary for their support. For there is no man so indigent or wretched, but he may demand a supply sufficient for all the necessities of life from the more opulent part of the community, by means of the several statutes enacted for the relief of the poor, of which in their proper places. A humane provision, yet, though dictated by the principles of society, discountenanced by the Roman laws. For the edicts of the Emperor Constantine, commanding the public to maintain the children of those who were unable to provide for them, in order to prevent the murder and exposure of infants, an institution founded on the same principles as our foundling hospitals, though comprised in the Theodosian Code, were rejected in Justinian's collection. These rights of life and member can only be determined by the death of the person, which is either a civil or natural death. The civil death commences if any man be banished the realm by the process of the common law, or enters into religion, that is, goes into a monastery, and becomes there a monk professed, in which cases he is absolutely dead in law, and his next heir shall have his estate. For such banished man is entirely cut off from society, and such a monk, upon his profession, renounces solemnly all secular concerns, and besides, as the popish clergy claimed an exemption from the duties of civil life and the commands of the temporal magistrate, the genius of the English law would not suffer those persons to enjoy the benefits of society who secluded themselves from it, and refused to submit to its regulations. Footnote: this was also a rule in the feudal law. End footnote. A monk is therefore accounted civiliter mortuus, and when he enters into religion may, like other dying men, make his testament and executors, or if he makes none, the ordinary may grant administration to his next of kin, as if he were actually dead intestate. And such executors and administrators shall have the same power, and may bring the same actions for debts due to the religious, and are liable to the same actions for those due from him, as if he were naturally deceased. Nay, so far has this principle been carried, that when one was bound in a bond to an abbot and his successors, and afterwards made his executors, and professed himself a monk of the same abbey, and in process of time was himself made abbot thereof, here the law gave him, in the capacity of abbot, an action of debt against his own executors to recover the money due. In short, a monk or religious is so effectually dead in law that a lease made even to a third person during the life, generally, of one who afterwards becomes a monk, determines by such his entry into religion. For which reason leases and other conveyances for life are usually made to have and to hold for the term of one's natural life. The natural life being, as was before observed, the immediate donation of the great Creator, cannot legally be disposed of or destroyed by any individual, neither by the person himself, nor by any other of his fellow creatures, merely upon their own authority. Yet, nevertheless, it may, by the divine permission, be frequently forfeited for the breach of those laws of society which are enforced by the sanction of capital punishments, of the nature, restrictions, expedients, and legality of which we may hereafter more conveniently inquire in the concluding book of these Commentaries. At present I shall only observe that whenever the constitution of a state vests in any man or body of men a power of destroying at pleasure, without the direction of laws, the lives or members of the subject, such constitution is in the highest degree tyrannical, and that whenever any laws direct such destruction for light and trivial causes, such laws are likewise tyrannical, though in an inferior degree, because here the subject is aware of the danger he is exposed to, and may by prudent caution provide against it. The statute law of England does therefore very seldom, and the common law does never, inflict any punishment extending to life or limb, unless upon the highest necessity, and the constitution is an utter stranger to any arbitrary power of killing or maiming the subject without the express warrant of law. Nullus liber homo, says the Great Charter, quote, aliquo modo destruatur, nisi per legale judicium parium suorum aut per legem terre, end quote, which words, aliquo modo destruatur, according to Sir Edward Coke, include a prohibition not only of killing and maiming, but also of torturing, to which our laws are strangers, and of every oppression by colour of an illegal authority. And it is enacted by the statute 5 Edward III, chapter 9, that no man shall be forejudged of life or limb, contrary to the Great Charter and the law of the land. And again by statute 28 Edward III, chapter 3, that no man shall be put to death without being brought to answer by due process of law. 3. Besides those limbs and members that may be necessary to man in order to defend himself or annoy his enemy, the rest of his person or body is also entitled by the same natural right to security from the corporal insults of menaces, assaults, beating, and wounding, though such insults amount not to destruction of life or member. 4. The preservation of a man's health from such practices as may prejudice or annoy it, and 5. The security of his reputation or good name from the arts of detraction and slander are rights to which every man is entitled by reason and natural justice, since without these it is impossible to have the perfect enjoyment of any other advantage or right. But these 3 last articles, being of much less importance than those which have gone before, and those which are yet to come, it will suffice to have barely mentioned among the rights of persons, referring the more minute discussion of their several branches to those parts of our commentaries which treat of the infringement of these rights under the head of personal wrongs. End of Part